We are really comfortable working in collaboration with business and trying to make sure that we get the right advice at the right time. My name is David Rushmere. I'm one of the co-heads here of the Employment and Immigration Department at Machin's. We're going to be talking a bit about employment tribunals, what it means obviously for employers and employees who might be thinking about bringing a claim in the employment tribunal or responding to a claim in the employment tribunal. To start a claim in the employment tribunal, the individual, normally the employee, they bring the claim. They have to go through ACAS early conciliation. That's a process where an ACAS mediator tries to broker a deal between the two parties. They won't try and speak to the parties about whether they've got a good case or a bad case. They'll just simply try and ferry between the two parties and broker a deal. But if that process doesn't work, if it's not successful, then ACAS will issue what's called an early conciliation certificate. And that number is what the claimant needs to actually start a tribunal claim. And they use a form that's called an ET1 form. You've got to provide specific information to a tribunal to start a claim. In an employment tribunal, neither party has to be legally represented. Both the respondent and the claimant can take the case all the way through to a tribunal hearing without any legal representation at all. They don't need to take legal advice in order to present their case. The general rule in employment tribunals is both parties bear their own costs. And there's clear policy reasons for that. If you think about a claimant, they've just been dismissed, they've probably got no income. If they had to take on the risk of paying their employer's costs if they lost the case, most employees just wouldn't be able to afford to bring a claim. If two parties want to come to a deal to resolve their case, so effectively for a claimant maybe to give up their claim and to take a payment instead from their employer, you've got ACAS conciliation, or you can do it through a settlement agreement. Settlement agreements are often done even before tribunal claims. Sometimes they're done as an early step in the process to end employment and completely avoid an entire tribunal. The evidence in employment tribunals generally is of two kinds. It's documentary evidence and it's witness statements. Documentary evidence means the contemporaneous documents relevant to the particular time. The other is the witness statements. So that is effectively the claimant and the persons involved from the respondents will actually give oral evidence to the tribunal, so they will explain what happened. To gather all of the evidence that goes into the bundle, both parties largely have to cooperate. Most of the documents are with the employer. Often an employee will have copies of all of those, but obviously only the ones that have been sent to them. But we go through a process of what's called disclosure. And then what that will be is the tribunal will order a specific date by which both parties have to send to the other every document that they've got that's relevant to the case. Best advice if you're a claimant, you have to be really, really careful about legal spend. Be cautious about going to a solicitor and incurring a large spend straight away. You really want to make sure that you get good quality legal advice, which is what you'll get from Machin's at a good price. So just get in touch. If you want to speak to any of our lawyers, call through to the front desk and ask to speak to one of our employment lawyers. We will happily then fix up an appointment for you to take a bit of background, and then we'll put you in touch with one of our lawyers so that they can then talk to you about what's happened, talk to you about your legal rights and advise you on your first steps, if that's unfortunately where a relationship with your employer has got to.